All of you want my views on Supreme Court judgment into GP Infra versus State of Madhya Pradesh on Section 74. If you ask me one-liner on this on this judgment of Supreme Court under Section 74, it is that numbers alone will not open the doors of Section 74. Facts and intent to evade tax are the preconditions. This is what Supreme Court judgment says. This is a huge judgment which is under Article 141. It is not SLP dismissed as threshold. It's after notice, after stay of the earlier judgment. The facts are, Section 67, such took place and a show cause notice was issued for 1.53 crore rupees on numerical figures basis without any actual description of Section 74 ingredients, that is fraud, willful suppression, etc., and intent to evade tax. Madhya Pradesh High Court, as usual, said appellate remedy, go back, which is what most of the high courts do. But the petitioner counsel took it to Supreme Court. Supreme Court stayed this, and they said we will hear it. So once the matter came up for hearing as per this judgment, the Supreme Court asked the question, does your Section 74 notice ipso facto, on the face of it, satisfy the ingredients of Section 74? One, that is, you simply have cut, paste, copied this 1.5 line of 74.1 and you invoke 74 without realizing, without bringing on record the actual modus operandi of the petitioner to commit fraud or to willfully suppress the matter with an intention to evade tax. The revenue said, no, we filed a supplementary counter-affidavit, etc. The judges refused. They say requirement is 74 show cause notice, not the subsequent development where the revenue tries to improve the ingredients and contents of show cause notice. So this affidavit they refuse to look into, and this is a very important observation. So what does it mean? It means numerical figures, templated show cause notice based on language of 74.1 without any justification, without any modus operandi, without bringing substantial evidence within the show cause notice. How was the fraud committed? Supreme Court says, well, numbers alone will not open doors of Section 74. But the material evidence in show cause notice with an intent to evade tax is the cornerstone of Section 74 jurisdiction. In my lectures all over the country, I have always maintained that Section 73 and 74 are conditional jurisdictions. There is no inherent jurisdiction with the proper officer to invoke Section 73 and 74 unless the conditions specified therein are satisfied. Both the provisions are same, except 74 carries intention to evade tax, fraud, willful suppression, etc. The only difference is extended limitation. 74 takes 5 years and 100% penalty. Against Section 73, 3 years and max penalty 10%. And even in case of earlier payment, Section 74 requires a minimum 15% penalty. So the difference is huge. First 2 years extended limitation and then the penalty amount. So therefore, this judgment has opened the doors for, again, huge litigation in high courts. So once you get a 74 notice, you have to, as a lawyer, as a professional, test that notice on the cornerstone of this judgment. Does the notice only give judgment, cancel dealer so much input tax, non-existent supplier so much input tax variation mismatch, these per se will not amount to section 74 now, unless the proper officer is able to corroborate this with the modus operandi adopted by the taxpayer to evade tax by materially suppressing the fact and by committing frauds. So this is a very important thing. Therefore, if you get a 74(1) notice, follow it and invoke writ jurisdiction. And High Courts will have to hear it now. Delhi High Court said 74 we will not hear. We had this Honorable Judge, Madam Pratibha Singh. The judgment, according to me, was very harsh. How can a judge say I will not hear this? Because each case is factually different. Now, what are the offshoots of these judgments? In fact, I made a video a few days ago on this issue. I will repeat this issue. Generally, by default, if 74 notices are quashed or 74 orders are quashed, then by default, generally, 73 limitations are also over. So what does it mean for professionals? So if a notice under section 74 is issued to you after the limitation of section 73 was over, most of the Delhi GST officers UP GST officers have done this. That is, they did not issue any notice within 3 years. They issued notice under section 74 just to pass an order. So if such notices or orders are quashed on the cornerstone of this judgment, so this means 73 jurisdiction is also ousted. That is, the whole demand will collapse. That demand will become time barred. But if the 74 notice was issued within 3 years as per section 73 limitation, and if this notice is then quashed, then by the operation of section 75(3), revenue will get 2 years time to pass the order in section 73. Because if the 74 is quashed, then automatically it says 73 notice. So we have to be careful. Once you are challenging, calculate on a paper what was the time barring period under section 73 from date of annual return, or what was the limitation period of section 74. So if the 74 notice was issued after the expiry of limitation period under section 73, then put wholehearted effort in getting the 74 notice or order quashed, because then the whole case falls through. Whole case is over. That is very, very important. Whenever you file your appeals now before First Appellate Authority or GSTAT, raise a question of law. I always say you should never prepare an appeal without framing questions of law. You have to write factual matrix. The next heading has to be question of law, even before Additional Commissioner or before GSTAT or for High Court writ or appeal. So frame a question of law whether the ingredients of section 74(1) read with this judgment are satisfied. That is, whether the notice is issued only for numerical numbers in a mechanical manner, cut-paste copies, or in law we call templated language, or there is a sufficient material to prove that the petitioner was engaged in activities that are not allowed by 74(1). If it is not the case, then put your wholehearted effort to ensure the 74 order is quashed. Before appellate authority, you have to continue to quote the Supreme Court judgments and say that vigorously. This is binding upon you under Article 41. And if you do not follow, this will amount to contempt. Don't get scared as lawyers to write this language. Most of the people tell me, no sir, how can we write this? If you can't write this, don't do practice. Be very aggressive. Even in the tribunal, see GSTAT also, the members who are sitting there, they are very hesitant to follow Supreme Court or High Court judgments in toto. On a drop of a hat, they remand the matter. In this case, the matter was not remanded. The demands are quashed. There is no liberty given to revenue to issue a notice afresh because there is no limitation. Therefore, in all your appeals, frame a question of law using the language of this judgment, and if you are convinced a 74 notice is not maintainable, then you don't have to bother about any consequential magnitude of demand or penalties or interest, because if this notice goes, everything else goes. So put 80% effort on jurisdictional issue in all GST cases rather, not 74. Because I'm a person who first will look into jurisdiction. Can I win on jurisdiction? I had made a video on jurisdiction also. If you go through our YouTube of DGST group, you will have this video on jurisdiction. Therefore, friends, a very good judgment. Now this non-payment of tax by supplier, fictitious supplier, bogus billing, etc., etc. This can all you can win if you can win that 74(1) notice is not maintainable in view of this Supreme Court judgment. Well, friends, thank you so much.